7:38. My goal is to be done by 10 o'clock. That's my goal. That's my goal. Now, going to give you a heads up. Heads up. Change of strategy. I'm restructuring what I've been drafting as my reply affidavit to make my reply memorandum of law, which is a little bit of a nuisance with respect to formatting because there's a lot more formatting headache. But seeing as how I'm submitting an affidavit, Ron Beretti is submitting an affidavit in my name on certain facts. I just feel like if I submit a memo of law, it's better than having a second affidavit or affirmation or whatever. So that's what we're doing. Memo of law. I've already started moving stuff over towards creating as a memo of law. And yeah, that's the goal. That is the goal. Joe, stop posting. Oh, posting. Of course not. Can you guys hear me? Am I talking to myself? All right, let's get to work. Oh, there's no paragraph. There's no moving things over. So I remember what we start the preliminary statement. I mean, it doesn't technically start with that. The body of it starts with that. First, you have your technical stuff, which I stole from the last memo law, courtesy of Debbie, who assisted me with the formatting on this. So we start the memo law. Petitioner Joseph Neerman in reply. This I'm going to end up changing this particular information. We follow up with the table of contents, followed by table of authorities. And then you get into preliminary statements. We basically make an initial statement. Now, my preliminary statement is more important in the initial memo that I submitted originally, but it reads currently. So I had to tweak that. The memorandum of law, this should be capitalized. This memorandum of law submitted on behalf of petitioner Joseph Neerman reply to the papers filed in opposition to the instant application. Respondent has not submitted an answer beyond the response to Article 78. What they did was Lisa Evans from the Office of Court Administration acting on behalf of Judge Merchant. He's the respondent. He's the only respondent. The District Attorney's Office is not a respondent. And I sort of I'm holding their feet to the fire from the get-go. And this is something that Ron was really pushing me to do harder, so I saw that incorporated in my preliminary statement, which is, so they write a one-page response to the Article 78, and then the Assistant District Attorney writes a 37-page verified answer. The verified answer is supposed to be coming from a party, not from someone who's perhaps inside the case, not inside the case. That's not an answer. If anything, it's a brief, it's an affirmation, it's something other than that, but it's not a petition or a response petition or an answer to petition. Those are pleadings. The pleadings are supposed to come from the parties. The district attorney is not a party. This is not just a technical thing because the status of the district attorney in this case is a little bit perplexing. They're not here. There's no court order saying that they are made a party. The only reason I served them was because the statute doesn't say I have to serve them. So the only reason I served them is to meet approval with the clerk of the court, but the clerk doesn't have authority to make someone a party. It was like a technical thing that if I wanted to get in there, I was going to have to serve the DA. Why is the DA the one serving a verified answer? It makes no sense. It almost shows their unity and interest. It's like it's hard to figure out where the district attorney's office ends and the court begins. It's very strange. It's very, very strange. So without phrasing it quite like that, I call attention to that by basically saying, respondent has not submitted an answer beyond response to Article 78, because which is a mere one-page restatement of petitioner's objectives within the underlying proceeding. All they say is, petitioner filed an Article 78 looking to overturn certain orders. That's all it says, and here are the orders. That's all it says. It doesn't say anything about it. Maybe they agree, maybe they disagree, I don't know. In lieu thereof, the respondent seems to rely upon the purported verified answer submitted by unnamed party, Assistant Attorney Philip Tisney, presumably on behalf of the District Attorney. While the District Attorney's Office may have a right to apply to be heard as an interested party, petitioners are unaware of any such application being made or any order being granted by the court. No order from the court directs or authorizes the District Attorney to submit papers on this matter. They don't say anywhere that they have a right to submit papers. No statutes known to petitioner create jurisdiction for the District Attorney to plead individually or on behalf of the respondent. There's no law that's written that says that they have a right to file pleadings for themselves or on behalf of Judge Merchant. Its current status remains unadjudicated and somewhat perplexing to petitioners. It's my way of just pointing out what the hell is happening here. What the heck is happening? I don't even understand. This doesn't make any sense. Why would an ADA be putting in an answer for a judge? You're a prosecuting branch. It's weird. It's very, very weird. It's very, very weird. That's my... For whatever reason, my video didn't start to partway through your intro. If you need help with formatting, let me know. I'll put marks in the authorities, so I hope it doesn't confuse you. No, you're great. You're great. I actually used what you created, and I just started editing a brand new memo based off of that. So I think that should be good. Thank you. All right, background. Most of the factual background is detailed in petitioner's verified petition. The papers submitted in support of temporary... The application for a temporary restraining order that was filed contemporaneously therewith. Petitioner Joseph Neerman respectfully refers back to petitioner's earlier filing for a full explanation of relevant facts that predate commencement of this application. The relief that petitioners seek, and this paragraph I put in here really just so I can have some of these terms get defined out of the gate, so I don't have to redefine them all over again, because I like the way I defined them in my initial application. So I say the relief that petitioners seek is that in the criminal action precedent before the Supreme Court of the State of New York, referred to as People versus Donald Trump, and referenced therein by indictment number 71543, hereinafter referred to as New York action, and Donald Trump is referred to as Trump or defendant, that the court immediately overturned the decision and order dated and entered with the clerk of the court on March 26, 2024, on the ORS order, that the court immediately overturned the CORS order, which was the follow-up order of April 1st, and such other and further relief as the court deems appropriate. After the court denied petitioner's application on... That's not right. On or about April 30, 2024, the court issued a decision ordering the people's motion for contempt, the contempt order. Copy of contempt order is next here too, made a part hereof is Exhibit 1. In the contempt order, respondent concluded and then I put the language in the contempt order. And I want to come back to where I wanted to start moving things around because I wrote most of this already. Someone gave me a link yesterday in Locals, which gave actual court. What? How can I get this download? This is the error I'm getting when I try downloading. Are you here, fans? Fans, are you here? All right, here's my link. This worked yesterday. There we go. Okay, fine. Thank you. Can I copy this? Well, that would be too easy. Of course, that would be too easy. Damn it. Yes, I knew that. Come on. Damn it. Damn it. Damn it. Damn it. Give it to me. F it. I'm going to just screenshot it. Screenshot it. Okay. Microsoft 11 sucks. My thing updated, and I don't like how this whole thing is doing this. I have snip and sketch. Where the hell is my snip and sketch? Damn it. Windows logo. Key. What the hell is this? Wasn't 5.2, was it? So hey Ron, I'm live streaming by the way. What was that? What was that? Um, sorry, I couldn't. I would be losing attorney-client privilege if I like talked on the phone in front of him. No, I'm talking to my audience here. Hey Joe, what time is the hearing? Will it be on the New York State Court of Appeals YouTube channel? It won't be the Court of Appeals YouTube channel. It will be on the First Department's. Remember, God is with you and will be tomorrow. I wonder if this is considered sufficiently legible. That should be hours. I'm working on this thing. I have to finish this now. Next. Jesus. Really? That's pretty cool. Yeah. Law change 1124. Notary no longer needed. All witnesses can affirm on the CPLR 2106. Much better. Dash 2.4. Yep, that's 5-2. Okay, now I gotta put these stupid pictures into my. The heck is happening here? Insert. I took it down wrong. I took the wrong page. Insert. That was 1942. It's gonna make me crazy. Yeah, I saw. Good sign. Good show. What are we saying? Great. No problem. Somehow I didn't end up taking this one down. Very low. Maybe I'm just getting frustrated with me. I'm just getting very frustrated with me. Just getting really frustrated with me. Everyone's going out for dinner, and I basically told them I can't come. And it's just asked me if I had any cash on me. And I told her no. She's not happy with me. This is 524. Insert. This device 525. Okay, good. I just took everything I had from the affidavit and moved it over to my new memo of law. That's what I was just doing. Now I put in the transcript, and I got to edit out the language that I had. Also, you don't number the paragraphs on this type of document. Windows circling this as the effect. Not effect, it's effect. Broadening the orders even further than the words around the page. It's difficult to interpret the orders. Anything less than a call to chill a defendant from engaging in free speech, even if it's not directly prescribed by the orders, or risk running afoul of commands issued from the bench. Oh, I missed some stuff here. What's going on here? Shepard establishes the duty of the court to protect the defendant's right to fair trial, not to gag him. Court's ruling is an abomination of Shepard. Oh, that's what my movement papers are all about, my friend. For at Rabbit Sick wants to make sure number 14 from last night was fixed. I can't remember what the hell number 14 was. Just tell me changing it. I don't know. The staff is only is evident. Because this is good. Let's go into our legal arguments. Need to get my story straight. Higher than the Empire State. Okay, I think this is good. Verified answer.
Sorry.
I don't think I have the keys to your van.
No, your car.
What's happening here?
They're taking my van.
Lori has my keys. What did I call that? The other thing. Playing with this situation is, do I need to be reading this to you? Can you all read along with me? I think you can all read along with me. I gotta get work done. So what do I want to call this? I'm gonna call this. Label this section of my paper. I am awfully quiet today. I feel like I gotta get stuff done. I'm awfully quiet today. When events of consequence unfold, two actions rarely result. Political leaders aggressively comment about the comment, and lunatics engage in obscene behavior. Justice Brett Kavanaugh is being confirmed, and again, when the Dobbs v. Jackson decision was leaked to the public, countless political leaders, including New York Senator Chuck Schumer, issued vitriolic statements against Justice Kavanaugh. Unhinged individuals issued death threats, and one person, let me see, went so far as to lead to a charge of attempted murder. That was a Supreme Court justice. When Kyle Rittenhouse was charged with murdering Joseph Rosenbaum, Derek Chauvin was charged with murdering George Floyd. Countless political leaders used their platforms to issue vitriolic statements against the accused. Those defendants faced a barrage of death threats or were harangued inappropriately by reprehensible anonymous people. Nicholas Salmon, Alex Jones, and scores of politicians have routinely been excoriated by politicians and subsequently received death threats and or been inappropriately harassed. Politicians have a long history coming by today with great fanfare in ways that the subject may find intimidating. Sadly, obscene inappropriate behavior has become de rigueur. In 21st century America, it is the norm. It is rare to see scenarios where they do not occur. It is incredibly rare, however, for a court to ever find a causal link between politicians and the obscene behavior. The only thing unique about this scenario is that the respondent implicitly made a conclusory finding that Trump's statements are a direct cause of the subject of obscene behavior. No evidence was ever submitted by the to support a common causal link between. No evidence was made by judgment to establish that causal link. There are no reason to believe that subject conduct resulted from Trump's statements and the result from statements made by a third-party politician, some random talking head, or a headline issued by the media. All we know is this: Trump made statements typical of any politician. Defending claims there was purportedly inappropriate conduct from unknown third parties. And the defendant has insufficient knowledge to refute whether or not the defendant's district attorney claims are true. Objectively, it may seem like that the claims made by the district attorney are true. The reason it seems so likely is because that is what invariably happens. What is so highly unusual about Judge Merchand's findings I'll find a different word for unusual. It's not unusual to be the thesaurus.com. Don't give me the infrequent if I'm something stupid like that. Usual. What do you got? Amazing, astonishing, awesome, bizarre. Bizarre seems strong. Curious. That's a good one. Noteworthy. Singular. I think curious. Curious is probably the best one. The typicality of dual occurrences, i.e., that it's been barely followed by both political vitriol and lunatics acting obscenely. He assumed that in this instance A caused B, while history indicates A and B are completely unrelated to defendant conducted an evidentiary hearing, perhaps causal link could have been established to justify a gag order. I don't like this. This sounds too colloquial. The court's baseless conclusions. Emptying the system for 30 plus pages about the purported gravity of the decision unique, nor comes the heavy resumption it's constitutional against. Perhaps, recognizing the tenuous legal footing of respondents' orders, it's not adverse counsel. On legal findings of other courts where Trump has been gagged. The legal vacuity of the orders finds no reprieve through any prior rulings. Is the subject is it fines or fines? Because it's the subject is the legal vacuity, that's singular. It's the orders. Put it like this: the order's legal acuity. That's and singular. The order's legal acuity find no reprieve through any prior rulings. Love it better, stronger. See, this is a sentence that Thomas Jefferson would write. He would. He's my yardstick. I'm like, if Jefferson would write that, then that's a good sentence. Decisions issued by Judge Chuck and the The gag order issued by Judge Ankron was in a civil trial, and its scope was far more limiting than the sweeping orders issued by the respondent. Ankron specifically limited his gag order to restrict Trump from attacking court staff. Trump was completely free to attack witnesses. Any of the attorneys working under James. am champion, unrefuted. Trump finds people in legal argument. Bum, 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 da, 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 da. Where should I put that? Really? Right, into the whole B thing. Before when I put in B, you didn't want B, now you want it. Now I gotta come up with a title for this. Let's see. Prior orders issued against Trump provide I want to say that the gag orders issued against Trump don't really give as much. Doesn't give merchant anything to work with. I know. I don't like this at all. This is a placeholder. Rhino measuring stick. That's terrible. Our gag orders issued against Trump. It's terrible. My God, it's terrible. Our gag orders issued against Trump. That's the sentence. That's better. No, remember Rudy just gave me a case and a quote that was really awesome. Look at this. Is the individual defendant to whom the Sixth Amendment guarantees a fair trial. It is the public to whom the First Amendment guarantees reasonable access to criminal proceedings. And it is individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage to the government must tolerate it. The government is our servant, not our master. This is not binding on this court here. The circuit judge. Where was this case? He didn't even give me this part here. I like this part too. If the combined workings of these constitutional guarantees, coupled with the operation of reasonable restraints of professional responsibility applicable to the attorneys in a case, should result in an atmosphere that threatens the ability of the government to try defendants in a fair forum, the trial court still would have available other remedies suggested above. See Nebraska Association. Although in unusual situations the balance may occasionally tip against the prosecution, this is an inevitable result of our deep-rooted American tradition of open judicial proceedings. This is exactly what my point is. Exactly what my point is. This right here. Who wrote this? Who wrote this brilliant decision? Trump is not the government. We see the time when he's being charged with regardless of member of the press. You're definitely covered. I don't know what that means in this context. Everything about this. What is this case? USB Ford. U.S. District Court for Eastern District of Tennessee. Damn it. That's really not very persuasive. This is good, though. The ABA Standards of Criminal Justice. This is more citable. Once parties and witnesses in a criminal case are outside the courtroom, they have the full prerogatives of any private citizen to question, criticize, or condemn the actions of the government, even though they may be swept up in its processes at the time. Okay. The scroll kick on a Kaiser. No, rodents are not kosher. Come on. What are you wasting my time with this for? What? What? Sixth Circuit. Sixth Circuit. Sixth Circuit. Mm-hmm. Before or after? Distinguishing. Wow. What happened here? Oh my God. No. God. That's terrible. What the heck was that? This is such great language. Everything here goes on and on. Look at the genius of this language. It's almost like they're like Joey, take me, use me. Yes, I will. Yes, yes, master. Yes. So much language. That's amazing. I can't use all of it. Let's take this paragraph out. In CBS, the reply to claim. As indicated clearly in the CDS case, such broadly based speech in connection with litigation is seldom, if ever, justified. Okay, this is where we're start. This is good. That's what I wanted. There's a really long quote. Really long quote. Really, really long quote. Really long. I don't know if I've ever used a quote this long in my life. I'm gonna have to break it up. I'm gonna have to break it up. It's too long. Too long. I'm not taking it on either. As long as ratio cake doesn't exceed 1 in 60, then we're still good to go kosher-wise. Oh my god. Stop it! Oh my god, now it's to explain to you Batal Bashishim. No. What drop barracuda is referencing here is in laws of kashrut, what is kosher, what is okay to be eaten by Jews. There's a concept that you won't taste the flavor of something if it's less than 1/60, if it's less than 1/60th of the overall thing. So it's acceptable to eat it even if something falls in that's prohibited, like squirrel. If it's less than 1/60th. That would only be permitted what we say bidi evid as opposed to lichachila. So if something happens to fall in, then we'd be like, well, after the fact, it's there now, so okay. But to say from the get go that you're going to be putting it in, no. God. That's my citation. That's my citation. .830 F second 596. Okay. Defendant's interest in replying to the charges and associated adverse publicity thus is at a peak. So is the public's interest in the proper function of judicial machinery. The accused has a First Amendment right to reply publicly to the prosecutor's charges. And the public has a right to hear that reply because of its ongoing concern for the integrity of the criminal justice system. And they need to hear from those most directly affected by it. Freeman, Starwood, prior restraints on freedom of expression by defendants and defense attorneys. Beautiful. Beautiful. It's got a nice little law review citation there. I'll just show like to pretend that the justification. If your petitioners claim the judgment have no legal right to engage in balancing testimony of his competing constitutional interest, adverse counsel cites 3 cases. Now, one of those cases deal with prior restraint on free speech of a criminal defendant. T.L. Thomas Shepard deal with court's rights obligations to curtail potentially intrusive media content that would incapacity to harm a criminal defendant. It is entirely consistent with petitioner's claims that the court engages in a balancing test exclusively when First Amendment rights conflict with defendant's right to a fair trial. Gentile dealt with restricting free speech of an attorney. The Gentile court. There's no relationship. I don't know what happened there. I can start spinning on me. Yeah. Well, good luck with that. Analogy time. Time for me to come up with an analogy. It's a different topic and. Love it. I don't love it. Thank you for the study night Kool-Aid, dear leader. My tracks is covered in dust. May I please have another? Oh, dust that sucker off. Dust it off. It's already 9:11. I'm supposed to be done with this. Let's be done. Done. They promised me I'd be done by now. Thinking about distinguishing from like mob bosses. I'm getting a lot of flack about how sweeping I was in my language, that I said there's no such thing as issuing a gag on a criminal defendant. I'm getting a lot of flack, and Ron Baruti was the most recent one to throw this at me, saying there are cases where they are silenced. Those cases are mob bosses, and what they're silenced from is engaging in illegal speech, meaning they're silenced from tipping off their cohorts as to who to kill and ordering a mob hit, which is conspiracy to commit murder. The speech itself is illegal. We're afraid they're going to engage in that illegal speech, so we gag them. That's the only time that that we have a prior restraint. Do I want to walk down and explain this to the court? That's my question. Do I want to bother explaining that to the court? What do you think? Should I explain it to the court? It's lost on you? The point is, it's two different sports. It's lost on you? I don't really love the analogy anyway. Cherry picking, I don't like the analogy. I agree with you. Cherry picking select passages from Gentile construct a license to issue a gag order on a criminal defendant is akin to using. It's a different topic. It's got like nothing to do with this. I think I should bring it up to point out the absurdity. I'm bothered by the fact that this is lost on some of my readers. If it's lost on some of you, it could be lost on some members of the court. It's akin to, and I don't really love the analogy anyway. So we're going to change this. Maybe I can get biblical. Biblical's not bad. My pleasure, brother. Biblical's not bad. I like select passages from like story of Cain and Abel to learn. You know what? I'm going to take out Gentile because I don't like Gentile. Cherry picking select passages from those cases. To construct a license issue a gag order is akin to cherry picking passages from the story of Noah to construct a license to abuse animals. Better? Is that better? Does that make you all happier? Is that better? I think that's better. I think that's better. What's happening? Kathy wants my attention. Is there a way to have as an argument backup, or does it need to be in a doc? For appeal purposes, it's better in the doc. Similar to a footnote support if they seem unconvinced. Oh, you're talking about the whole. Oh, that part as far as like the whole mafia thing. Yeah, that I can refute later on. See, the mafia thing is not something that's brought up by my adversary. If it was brought up by my adversary, I'd raise it here. It's not really brought up by them. New York Court's Appellate Division First Department, where this will be heard, has a channel at NYSAD1. It looks like they stream it every day, so hopefully we can watch there tomorrow. See, I'm thinking of live streaming that here on Good Logic. I'll turn it on and just share it out and then pop in here if I'm done in court. Curious intent to refute past one first time with assistance from the sites. The notion of this interest case sufficiently compelling need. Mm-hmm. Such a great quote. Such a great quote. Oh, thank you, Bear. You're too cherry picked. Do I really? Twice in the same sentence, paragraph, I think. Yeah. I was saying, love this quote. I'm going to marry this quote. I want this quote to have my babies. Hey there, I want to wish you luck. You got this. Also, might want to pin your G and G link to the chat. Sharing streams for easy access. I really should have done that, shouldn't I? Totally forgot. Just thought. Knock 'em dead, Joe. I don't know why I didn't do that yesterday. I don't know. I suck. Definitely should have. I haven't even looked at my gifts and gold right today. No idea where it's at. Cal. Court's page. Live streaming images, video recordings of the court's justices on the court's website or otherwise may not be used to advance private interests or in furtherance of any commercial purpose. Video recordings of the court's justices on the court's website or otherwise may not be used to advance private interests or in furtherance of any commercial purpose. That sucks. That sucks. If I live stream this, yeah, they might come after my license for that. It sucks. I need some music. I need some hard music now. I need music. Mother effers. Ah! did it? Did it? Na-na-na-na-na. Let's see how it looks. Oh wow. Right. He told me when I told him I'm fairly confident I'll break 25. He's like, everyone tells me that, and then they never break 5. I was like, I don't know. I think I'm gonna be different. I think I'm gonna break 25. I think I'm gonna break 25. Where's my music? Music will cheer me up. There's one. There's my MP3. My phone. Text view. I know Viva was talking about streaming it, which I don't think he's bound by the court. Almost done just texting Viva. He's putting his kids to bed. Yeah, I don't think others can stream the courts live. It's BS in my honest opinion. Well, that's if they're subject to the court. I don't know. I'm not going to advise anyone to do that. That would be a violation. I'm not certainly not going to advise anyone. Does it count if you don't monetize the stream? I don't know. I was wondering about that also because I think they might try and twist it. That's the first thought I had. Is what if I don't turn on monetization? But it's gonna be very hard for me. It's very hard for me to do this without them saying I'm promoting this site right here. So I'm not gonna dance. It's just not worth the dance. I'm sure if this actually goes, we can push way past 25. Oh, I'm sure it's gonna go way past 25. It was at 1565. If everyone check it, $30 each, he would get the 25 call. My math might be wrong. Yeah, well, you cannot monetize specific stream. No commercial interest in. Yeah, but like I said, I think they might say I'm doing it to raise money for this give send go. I'm not dancing with it. I'm not going to dance with it. It's just not worth it. It's not worth it to me. Because they're going to be looking for reasons. I'm literally fighting against the Office of Court Administration. The Office of Court Administration is what governs my law license. And they are also the ones who are defending Judge Merchant. So I'm just not doing it. Not dancing. It's just whatever. If I made $50,000, it's not worth it. It's not worth it. And I wouldn't make that anyway. So it's not gonna. I'm not doing this. Istanbul is not. No, it's Istanbul, not Constantinople. Everything in Constantinople is Istanbul, not Constantinople. Constantinople should be waiting. Istanbul was once New Amsterdam. Why? People just like it better that way. Let's not take no back to Constantinople. Nobody's business with Turks. whisk of my voice. No choice. Come on. You could go that. You could blow it this. You could blow it that. You could go with this. You could go with that. You could go with this. You can go with this. You can go with that. You can go with this. It's too nice to me.
Dad, it's too nice to you.
Thank you.
But yeah, it rejected me. They kind of messed up your order a little.
Of course they did. I didn't even make an order. They messed it up.
I got you a giant burger, and I told them what you wanted. And tomatoes. And then I'm like, which one?
Mustard on a hamburger?
Well,
How is
I
that even
didn't
a
know.
question?
I know you like one for something and one for something.
No, like all of humanity.
Well, they said they're gonna put it on the side, and the next thing I know, they put both of them.
Oh my God! Why? Why would anyone do that?
I don't know.
Why would anybody do that?
They said side.
I don't. This is like putting apple juice. Why don't you put apple juice on there? Some people like apple juice on their hot dogs.
Honey, listen.
Oh my! Everyone puts ketchup on a hamburger and mustard on a hot dog. That's what you do. Everyone knows
I looked
this.
at this yellow and red mess.
God,
and I'm like,
why?
I don't know what to do with this.
You should have told them no. Get that off.
What am I supposed to do?
That's what you say. You say I don't know what you're doing there. You said put it on the side.
You might like it.
I'm not gonna like it. It's not like I don't know what mustard tastes like.
With ketchup?
No, I don't care if it's with ketchup. Why would anyone put? No one ever put mustard on a hamburger. That's gross.
Well, you could try to sweep it off.
I'm not gonna sit there with my fingers and like I'm some sort of like retarded boy playing my food here. Why? Why would someone do such a thing to a hamburger? My God! It's so stupid. It's craziness. Why wouldn't you just call me and say, do you like... It was nice that she thought of me. All right. They're fries. They do this Texan style fries thing. I'm sure you guys are used to seeing stuff like this. Oh my God. That is, I don't know if you can see it. Fries with pulled beef on top of it and fried egg. So good. So good. I don't know where I'm gonna have room for any of this. I think I have room for any of this. I'm just distracting me with my stomach. Why would someone do that? God, who puts ketchup on a hamburger? That's crazy. God, I guess sulfur was unavailable. We're all out of sulfur. We'll use the mustard instead. Mm. You don't want ground ginger on your hamburger? No. Just freaking normal hamburger. God, I don't understand it. I've been living here a while. What's happening? The math might be right. You're very adamant about the whole math thing. You're not getting $30 from every person watching this stream, and you're not even dealing with the right numbers because whatever numbers you're seeing on YouTube where you're at, on there's actually 3,000 people watching this all together right now. So I can do the numbers for you really fast. $3 a person. Three. Okay? $3 a person would cover it. So yeah, I think I don't know what you're talking about. 320. I don't know where you see 320. I see 3,000 live watching in a second. Yeah, don't go in like a First Amendment auditor. Just another $145 and it's 19,000. What? What? 16,000. People are 16,000. Too small for you to see, maybe. 15. Maybe I do small for you. Keyboard and paper bag ASMR. How do we get so? I don't know. Ketchup and mustard on a burger. No. Mustard gate. Oh, thanks for calling out almost entirely waste on mustard on burgers, Joe. It definitely goes. What? Thank you, Shauna, for dinner. Sorry about the mustard. Thank you, Shauna. Mustard is gross. Exactly 0 people bought me food tonight. This is true, and I appreciate it. McDonald's puts ketchup and mustard on their basic hamburgers, not the Big Mac or Good Burgers, but the basic one. Yep. That's how I'll phrase it. Basic liberty. That's how I'll phrase it. It's with respect. It's a veiled way of leaving an exception for gagging some RICO defendant who's might order a hit. I think I'm actually much closer to being done than some of you may realize. Much closer to being done. I just got to do this part. We do this part, we're good to go. I'm going to just wash my hands real quick.
Badly enough that he didn't want to come back for it. So I was like, I just need a phone. This Savannah doesn't have one. Thank you.
Yeah, that's
I invited him for Shabbos. Then I really can't. The Shabbos, it's me, you, Donna, and Shimon. So I told Dad he'd come.
I don't know how to eat this in front of 3,000 people.
I don't know if there's any good way to do that.
Can you give me wall typing?
I figured that you'd want that.
Thank you.
So I also, they had leftover fried rice.
Thank you.
It's good. So I figured if you're still hungry.
Thank you. I appreciate it. Thank you. Can you give me some napkins? Like a lot.
I'll get
a lot of napkins, huh?
A lot of napkins.
okay, Miss Reese. No, you might have to take her to the doctor tomorrow.
I'm going to be in court tomorrow.
He's a cast.
I'm telling you that I have a court appearance at 10 a.m. That's on this thing. This application is scheduled for 10 o'clock.
Oh boy.
There we go. Fantastic. You guys are awesome. Thank you. Thank you so much. I thanked her. So mad. All right. This predicate being denied the ability to request an interview. Is that right? Do you have material just in case that your request is granted? I was already denied. I was already denied. You missed that. Take the 59.6 at the master. Shut up. This is literally lawyer mukbang. I can't even look at the size of this thing. That is one tasty burger. I can't even put this down. Do you mind if I get a beverage to wash down this tasty burger? What? It's getting cold. What should I do? So much mustard. I have to admit, mustard is not really disastrous. It's not really disastrous. The mustard's not terrible.
Well, it's not? Okay, good. I'm sorry.
No, it's an interesting wrinkle. And if I had a choice of both mustard and ketchup or neither, I would take both. Yeah.
Do you know if you're going to be around at like 4:30?
It should be around there.
Because Maureen needs to get to the airport, and I have an OBGYN appointment. Well, is it? It was bad timing. Their flight happens to have been changed, so it really was not my fault. Are you on the thing? Very nice. It's a well visit. I'm too old to be very.
I was like, wow. Okay.
No, honey.
Oh, okay. That's a weird way to say give me a message.
Yeah.
I ran out of burger here. It's got a bun. I don't like that. That's a mess. This is gross. Okay. to wash my hands. This is gross. Not 30,000, 3,000. 3,000 people watching me eat. It's not that crazy. I'm not Russell Brand. Hello, you wonderful, fabulous 8.4 million people. 8.3 million people. All right. Let's get to work. So I got my Texas fries. I like to eat with a fork. Filthy while doing it. Look at it. Look at it. Look at it. Look at it. Oh yeah. Mm-mm-mm. Mm-mm. That is one cheeseburger. Look at this. I think I'm up to the next. No, I'm up to point 2. And I don't think I'm going to get into the whole Sixth Amendment stuff. I'm like, F that. Screw that. Ron just seems to run off of the mouth about Sixth Amendment stuff anyway, so he'll cover me on that. I'm sort of almost torn to not even talk very much about Second Argument. I really want to get out this first thing here. Right, let me find his thing. Where was his thing? Look at this. You can look at that. Second, petitioner complains that there was an insufficient factual support for Justice Merchant's determination of defendant's unrestrained extrajudicial speech posed a serious imminent risk of impairing the proceeding. No, not what I said. He left out the key word, which is called key term, which is causal link. Very convenient. Very convenient. It's such a great quote. I almost want to finish with it. It's such a great quote. Let's get some music. Let's get some words on paper. Words on paper. Here we go. I want to talk to you. Don't judge me. Don't judge me. You're about to judge me. I know you're about to judge me. Okay, the TikTok thing just got in my head. I be like Grace Kelly, but all it looks for too sad. So I tried a little Freddie. I got a fancy man. I could be brown, I could be blue, I could be violet sky, I could be purple, I could be purple, I could be anything you like. Try to be me, try to be everything more. God. Help you? How can I help you? How can I help myself? I could be brown, I could be blue, I could be violet sky, I could be purple, I could be purple, I could be anything you like. Try to be green, try to be me, try to be oh, walk out the door. I could be violet. I could be purple, I could be purple, I could be anything you like. Try to be green, try to be mean, try to be everything more. Why don't you like me? Why don't you like me? Walk out the door. Try to everything more. You like me? Oh. Doctor Who! Doctor Who! On holiday! Hey, 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 hey. I want to freeze that. Freeze that. Thank you. Everything's fine. Everything's fine. Thank you. Feels like the climax of Guy Ritchie movie when someone's getting totally owned. I'm a big fan of Guy Ritchie, actually. Those who use gags should be aware that they can double as blindfolds upon themselves before a wall just says, tell them. Tell them. I know you want it. But you're right. All right, I need another song. It's playing on repeat. Simple. Go find someone like me when I'm singing falsetto. Wasn't me. Wasn't me. Wasn't me. Wasn't me. Wasn't me. Wasn't me. That's any better. No, make fun of me. Going downtown, baby, don't you know, baby, move, move, baby, let it go, show me pop-pops. Going downtown, baby, shoot you, baby. Downtown, baby, don't you, baby, boom, boom, baby. When I go, shimmy, go, pops, get up, go down. Mm. In the sky, ain't no road in the sky, in the sky. The blue sky. Why you had to hide so long, so long? It's the blue sky. Please tell us why you had to hide for so long. Extremely the significance of such terms filing. One expect that a party urging court to issue relief that has a heavy presumption of constitutional invalidity would come before the court with volumes of incidents, citing dates of Trump statements and subsequent third-party action close in time and nature. in your head someday, someday, someday. Ah, ah, ah. So much so. I don't like it. I don't like anything I'm writing. I feel like everything I'm writing now is crap. It's below mine. This is bad. This is bad. I don't know if I need it. I feel like I don't need it. It's time I feel like I don't need it. It's just like this is all stuff I've said already, one way or another. I think it's overkill. I think it's just detracting at this point. I don't like it. I think that's taking out everything after number 2. I do want to say something about the lack of. I'm trying to address the term. I think I'm just rambling. I'm just rambling. It's bad. It's bad writing. It's too wordy. No. Getting like too into the whole. No. Before I just delete this, let me take a whole different direction. This is an intimate in the case law of gates of courts. Don't they? Matter of the petition alleging the paper thing causal links alleged in the district attorney's motion says to the court to conduct an evidentiary and to have any opportunity of legally salvaging. This is clunky. This is very clunky. This is like this sentence is wearing clogs. Okay, I'm getting pulled into the weeds again. I'm getting pulled into the weeds. I'm going down the same stupid path again. Come on. I'll wrap this crap up. Evidentiary here is necessary steps to establish compelling need and narrowly tailored relief. attorney fails to establish a compelling need to get him because they not bother establishing a causal link. The respondent fails to establish compelling need to get him because they not bother to establish. Fails to establish compelling need because they do not bother establishing. They do not bother. That's not good English. Yeah, it's good English. It's just bad English. Kind of like the last sentence I said. Rather than the district attorney fails to establish compelling need to get him because they do not bother. I was going to say providing. Evidence. Jeremy Giesengamers wants you on his show. Promise he's not good at follow-up. Can you please reach out to him? You were on with him on Valiant stream a month ago. This will get you over 100K. You think so? See, I never know. See, this is an interesting thing that you're saying, and I always get very, very confused by this. Maybe, I don't know. I see how Legal Mindset tapped into the whole VTuber thing and like saw his numbers get jacked. It's a very weird thing to me to like for me to venture into arenas that I don't know anything about, like literally anything about. But people who are just based, let's say. This is something I've really struggled with a lot. I'm trying to wrap my head around. Like, okay, there's a lot of based folks out there who are in completely different spheres from what I'm doing. I'm talking about law and politics and things of that nature. There are a lot of based folks out there, and I can hang out with them and I can talk to them. And it's like, who the heck is going to start following a lawyer because of maybe, I don't know. I don't find that like I actually notice any increase in my numbers when I hang out with like some of these larger channels. It's nothing significant, really nothing. Yeah, I'm wrong. Yeah, okay, fine. If I was on Tim Pool, he's got like a lot of people who don't know me, and they would probably like a lot of the work that I'm doing. But someone who's into gaming, it's like they're not into like the some jackass drafting a motion online. Sit through this. Who the heck would sit through this? I don't know how you guys are here. I credit you, but it's a different perspective. It's a different mindset. And I'm just like, I don't know that that's gonna like do anything. Like that I'm gonna like resonate with them. They're just gonna look at me like I'm some old fart. And why is he here when he doesn't know anything about gaming? You know what I'm saying? It's like the same thing with like I like George the Giant Slayer. We're in Valiant. It's like I sort of like there's some minor overlap there, but it's like I'm like I don't know. People come over here from there because I'm talking about Disney and all the flaws there. Some people come, I just don't find that it translates really. I don't have a problem going out there. I'm always cool making new contacts. I'm just saying, as far as it actually like, getting me over 100K, that's really the part where I'm like, I struggle to buy that. I could be wrong. It's just my experience. Hit him with the if gag don't fit, you must dismiss. Never gotten the rumble rants, right? Asking for a friend. Are you asking for a friend? This is my first chat. And I just say there's no crime about hamburger topics. Okay, I totally forgot rumble rants. Nah, sir, Crip Nembim. I bought Ungag.Trump and forwarded it to your campaign. Slow Mo Savage on locals. Oh, very cool of you. Thank you. It is very cool of you. Thank you so much. Ruman says, would you consider gag as punishment prior conviction? We require bail that is returned upon appearance. We deny bail to protect the public, but gag seems like punishment. I don't know. I'm definitely not raising that issue. Just do it. Just do it. Always put mustard and ketchup on a burger. It was better than I anticipated, that's for sure. V-Sing says, when's this due? Any chance you can share a doc file? I'd happily give entire thing once over for a locals code. Great with grammar, experience at drafting specs, regs, knows good for you, odds and ends. I need to file this tomorrow. So yeah, I don't have time for any of that. But I appreciate the thought. Very much appreciate the thought. Thank you for calling that to my attention, Debbie. You're awesome. Let me peek in over here. I can be brown, I can be blue, I can be. Oh, yeah, that's good. Johnny Reb, just Jew it. Just Jew it. I'm starting to feel tired. I need to get to sleep soon. I'm gonna have to wake up soon. I have to start wrapping this up. I think I'm just gonna shave the rest of this and say F it. Let me brown again. What did I do here? Oh, that's confusing. Did I number those things? Legal analysis. Number this background. Take the number out of this. Then I got 3, and then I have another Roman number to throw. It's gonna be very freaking confusing. Center. Have you looked at Watts versus United States? No. Should I? This is really, when you say 11th hour, this is like 11:30 hour. Gold. This better be freaking gold. No, it's not something to touch. I'm not breaking into the nature of his comments. I'm not doing that triple dog. It's just not something. It's a whole other. That's a whole other animal. It's a whole other animal. It's a whole other animal, which in New York is a losing case. They're never gonna admit that his statements are not objectionable. They're never gonna admit it. Never, ever. It's a losing argument. Jeremy does a political show. He's very, very Trump supportive. Please reach out to him. I'll sacrifice the goat to make this happen. Not a call, just a Dante, what's the schedule look like this week? I have no idea. Seriously. Yeah, Paul eats mustard, especially on burgers. Can't do this now. I have to finish up. I'd love to play with you guys. Seriously, I'd love to come out and play. I'd love to come out and play. But I need to get to sleep. I have to be up like in 7 hours. So I need to wrap this. It's time to wrap. Well, I don't know if I'm going to want to look over because I haven't looked at his brief yet. I think he's watching me now. He just texted me in a second, asking if I'm streaming ready or both. Almost done. I gotta go through my table contents and all that stuff. I really want to read this again. So I'm sure there's going to be a lot of mistakes here. All right, let me read it. Let me see what we got. Let me see if I can start putting my bows on this. I gotta change all my cases. All my stuff. I don't know if you're watching this now, Debbie. I'm going to send this to you now, my current form, and ask you if you can start taking care of my table authorities and my table contents while I do my proofreading. Are you here, Debbie? Are you here? Dang. Dang. Wish I was your lover. Are you here, Debbie? Debbie. She's here. I'm emailing you. I'm emailing you now. Okay? I'm emailing you. I'm going to close this out so no one sees who you are, because that would just be rude. I'm going to save this. I'm going to ask you if you can take care of my table of contents, table authorities. I might have to change a page or two here or there, but that might happen. But at least this way I'll be like 90% done. I don't know if you have time to do it now. I'm assuming you do. And if you don't, I'll just take care of it afterwards. But meanwhile, I'm going to be doing my editing. Okay, I just sent that to you. Sorry, I'm just texting my attorney here. I'm working out like final details with this stuff. All right, so we got. I'm gonna see if I like this, hate it, or what. We'll see. I never know until I start going through it. All right. All right. Before I do, I just need a song. Gear myself up. Something good. Something good. Laser wolf. Yes, it is going to be Fiddler on the Roof. L'chaim, l'chaim, l'chaim to life. But here's to my bright to be. Drink l'chaim to life, l'chaim. L'chaim, l'chaim to life. That's a way of confusing us, blessing and bruising us. Drink l'chaim to life. God would like us to be joyful, even when our hearts lie pounding on the floor. How much more can we be joyful when there's really something to be joyful for? To life, l'chaim. My wife. Something to think about, something to drink about. Drink l'chaim. Tonight. Some of them have to reply to the baby's follow-up. Not submit an answer beyond a response to articles. To Laser Wolf, to Tevya, to title my daughter, my wife. Not like our present ones. Drink l'chaim to life, l'chaim. L'chaim to life. Willing to make us say, let's live another day. Drink l'chaim to life. Yes, and snaps in honor of this great for you. We know that when good favor is to such men, it stands to reason we deserve it to us and our good fortune. Be happy, love life. Fortune never comes, here's to whatever comes. Drink l'chaim to life. Seems to lie upon the poor. While the district attorney's office may have a right to apply to be heard as an interested party, petitioners are unaware of any such application being made by any order being granted by the court. No order from the court directs the representatives to submit papers in this matter. I'm saying the same thing twice. Zavasha Starovia. Heaven bless you both, Nostrovia, to your health, and may we live together in peace. Thank you. May you both be favored with the future of your choice. May you live to see 1,000 reasons to rejoice. It's not repetitive, it's good. What's the fat back? Petitioner Joseph Name respectfully refers back to petitioner's earlier filing. I was torn about whether or not to leave this as plural, possessive, or singular, because now I'm a singular. Before I was plural. That is why I know it looks confusing when you see the S apostrophe here and the apostrophe S here. That was intentional. I think it's correct. You know what? It wasn't my individual thing. I'm gonna do it. I think it's just gonna confuse people. They think I type it. They won't think They won't realize the deep thought I put into that. Early filing full explanation of the predate commencement of this application. Relief that the petitioners seek is that in the criminal action presently before the Supreme Court of the State of New York referred to as People of the State of New York versus Donald Trump in reference therein by indictment number hereinafter said action is referred to as New York action and Donald Trump is referred to as Trump or defendant. That the court immediately overturned the decision order dated and entered with the clerk of the court on March 26, 2024 on the people's motion for order restricting extrajudicial statements. Hereinafter said order is referred to as the OR's order. That the court immediately overturned the decision order dated with the clerk of the court on April 1, 2024 on the people's motion. Clarification when order restricting extrajudicial statements hereafter. Said order is referred to as the court's order and collected with the OR's order referred to as simply the orders. And such other further relief is court deemed appropriate. I never put a comma after the year, and I always used to do it, and people told me it was wrong, and now I keep getting these stupid blue things whenever I don't put a comma in. After the court denied petitioner's application on or about April 3rd, 2024, the court issued a decision and order on the people's motion for contempt. This is all different font size. This is a whole different font size. We're in a whole different font size. Well, that's not right. This is 12. This is 12. This is 12. This looks big. Yeah, this is big. I'm making this all 12. We're going to make this whole thing print 12. I don't like having multiple things. Debbie, if you're watching, make sure it's all in 12 font because that's going to move stuff. That's going to move crap. 12. Yeah, I just shortened like 2 pages. I don't know if you're watching, Debbie. I just lost 2 pages by moving everything to 12 font. Okay. Well, let me knock these out of the way. What are you going to say here? I know. Oh, I know. Ron noticed they're over 18K. He actually texted me. He's like, you're over 18 freaking K. Like, damn, Skippy. Woo! More than anyone, you got this. Go again. Thank you. My father, may rest in peace. You say I was like the oldest daughter in the fiddler. Still trying to figure out if he was an insult. I don't know. I never realized that Ellie could be a girl's name. I guess it could be. I was assuming a boy. But I guess I got that wrong. Maybe you're right about Mustard Captain ADHD. What? What happened? I'm looking at the format, including font size. Oh, good for you. Good for you. Good for you. All right. After the court denied petitioner's application on about April 30, 2024, the court issued a decision in the order of the people's motion for contempt. A copy of the contempt order is annexed here too. I mean, see, I don't. I don't know if I'm taking that out. It's really weird to put. You don't put it. I'm taking that sentence out. I'm not going to attach it. It's weird to put an exhibit to a memo of law. I've never seen exhibit on a memo of law. That's just very weird. So, F it. It's evident that Trump is currently attempting to comply with the restrictions that the respondent placed on his speech in the orders. Evident Trump's going to comply with the restrictions. With the orders restrictions on his speech. On or about May 2nd, 2024, Trump's counsel reportedly approached the bench and inquired as to whether or not Trump was legally permitted to post certain articles in his Truth Social account. This was a transcript from the subject exchange. Yeah, that's fine. Page 1941. This is 1940, 42, 43, and 44. When Hitler lost. Okay. There are three notable facts that the public can glean from the contempt order, as well as the report exchanges from inside the courtroom. The first, the defendant is sufficiently mindful of the orders that he's attempting to solicit direction from the court to ensure that he is complying with the directive. Secondly, Trump's counsel is struggling to properly interpret the orders as they apply to specific speech that Trump wishes to issue. Accordingly, even those trained in the law, are fearful that when applying the orders in a day-to-day setting, there is room for a difference in legal opinion. Finally, the respondent refuses to provide further clarification. Rather, Judge Merchant's response of "when in doubt, steer clear" necessarily has the effect of broadening the orders even further than the words written on the page. It's difficult to interpret the objective of the orders as anything less than a call to chill the defendant from engaging in free speech, even if it's not directly prescribed by the orders, or else he risks running afoul of the commands issued from the bench. More evidence of the defendant's mindfulness of the orders is displayed in an exchange between petitioners and Trump's staff. On or about May 3rd, 2024, petitioners emailed an inquiry to Trump's campaign. On or about May 3rd, 2024, petitioners emailed an inquiry to Trump's campaign asking 3 questions about the defendant's perspective on the trial. See Exhibit B, which is attached to Ron Baruti's thing. His staff responded they cannot respond to petitioners' queries due to the unconstitutional gag order imposed by Judge Juan Merchan. Accordingly, it is evident that the contempt order, notwithstanding that the unlawful orders are, accordingly, it's evident the contempt order, notwithstanding that the unlawful orders are 1, inhibiting Trump's free speech, and 2, directly harming the petitioners. Good. I'm okay with everything I see so far. So far, so good. So far, so good. I only got 8 pages left. All right. Okay. I'm the only person I know who hires a lawyer and then says, I'm still going to do my own stupid legal work. So dumb. I'm such a control freak. I literally hired a lawyer, and I'm like, I want to draft my own stuff. And I'll stay up till like midnight before I'm supposed to be in court at 10 o'clock in the morning, getting this stupid thing done. It's not an attack on him at all. I'm just like, I want to know that this part's getting in there. I want to know that this is in there. Petitioners claim that respondent misanalyzed the law remains unrefuted. Claim that Trump frightens people is not a legal argument. The district attorney purported verified answer invests heavily in attempting to portray the combination of Trump's comments and dishonorable conduct by unknown third parties as some unique new crisis affecting the judicial system in ways unprecedented. To wit, of the 37-page verified answer, the first 30, I think it's actually the first 34 pages. The first 32, first 32 pages dedicated to providing examples of 3 forms of conduct. 1, statements made by Trump, hereinafter referred to as Trump statements. 2, shameful conduct purportedly perpetrated by parties unknown to Trump or anybody else, third-party action. And 3, reactions of various people to being referenced in Trump statements or fearful that they may be referenced in future Trump statements. Presumably, counsel's point is that this particular situation is uniquely grave. The claim that this situation is uniquely grave is neither a legal argument or factual. Moreover, in this scenario, what were unique, that is not any form of justification to warrant upheaval of decades of Supreme Court First Amendment precedents that harmoniously direct this court to recognize respondents' orders as unconstitutional. I'm liking it. In today's political environment, when events of consequence unfold, 2 reactions invariably result. Political leaders aggressively comment about the event, and lunatics engage in obscene behavior. When Justice Brett Kavanaugh was being confirmed, and again when the Dobbs v. Jackson decision was leaked to the public, countless political leaders, including New York Senator Chuck Schumer, issued vitriolic statements against Justice Kavanaugh. Unhinged individuals issued death threats, and one person's lunacy went so far as to lead to a charge of attempted murder of a Supreme Court justice. When Kyle Rittenhouse was charged with murdering Joseph Rosenbaum and Derek Chauvin was charged with murdering George Floyd, countless political leaders used their platforms to issue vitriolic statements against the accused. Those defendants faced a barrage of death threats and were harangued inappropriately by reprehensible, honest people. Nicholas Salmon, Alex Jones, and scores of politicians have routinely been excoriated by politicians and subsequently received death threats and or been appropriately harassed by parties unknown. Politicians have a long history of commenting about the events of the day with great fanfare in ways that incredibly over aggressive. So that may seem over aggressive. If not inappropriate. Like that better. Sadly, obscene, inappropriate, obscene, harassing. Obscene and or harassing behavior has become de rigueur. In 21st century America, it is the norm. It is rare to see scenarios where they do not occur. It is incredibly rare. What is rare? However, I like it. However, it remains incredibly rare. However, it remains incredibly rare for a court to ever find a causal link between a politician's speech and the obscene behavior. Obscenely harassing. And third party. What's called third party? Obscene harassment. It's better. Better English. The only thing I know it looks like I go from Exhibit 1 to Exhibit B. I took out Exhibit 1 and Exhibit B is not attached here. I was not confused. You're looking at things that's pre-edits. Exhibit 1, I'm not attaching any exhibits to this. The Exhibit B I reference is an Exhibit B from an affidavit that I'm signing and I'm attaching to Ron Baruti's papers, not these papers over here. And I still don't like the fact that I call it Exhibit B, but I never even corrected him on that. So it's ooh, hoo, 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 hoo. Oh, thank you. You're too kind. I knew I she's like waiting way ahead of me. I know that. I know that. I'm well aware of that. I don't like that I have like 5 paragraphs in a row, which are each one sentence. That's a remnant from before I cut this thing down. Debbie, I'm gonna need you to work fast. I need to go to sleep soon. Don't sit back. I can change a page or two here or there in your stuff after I edit. But that doesn't seem so likely is because that is what invariably happens. How long do you think it's going to take you, Debbie? How long do you think it's going to take you? Judge Merchant's findings are curious. All we know is this. Trump made statements. We have no more reason to believe subject conduct results from Trump's statements than that they result from statements made by a third-party politician. So all we know is this. Trump made statements typical of any politician. I shouldn't say any politician. Say many politicians. Some are not quite the same rhetoric he is. Thank you. You too. While you're here, if you're peeking around here, you can just remember, by the way, this is for you. If you're peeking around, just gonna mention. Listen to the cartoon. Who knows? Okay. So all we know is this. Trump made statements typical of many politicians. District attorney claims with this purportedly inappropriate conduct from unknown third parties, and the defendant has insufficient knowledge to refute whether or not district attorney's claims are true. Objectively, it may seem like the claims made by the district claims should clarify this. Assuming that you really need to clarify that. That's important. I'm glad I caught that. Claims. So that clarify what's true, not the fact that they're linked. District attorney's claims. Increased during the past 14 months. Seems likely that this can come out better. Objectively, the district attorney's claims that the volume seems plausible. The reason it seems likely increased volume seems likely is because that is what invariably happens. Findings. Curious. I shouldn't put findings in quotes. That's dismissing. That seems rude. Feels rude. Judge Merchant's findings are curious. Judge Merchant's findings on causal link, however, are curious. Explain now. That's better topic sentence. Despite no hearings on the matter, the typicality of dual occurrences, i.e., that a significant event is invariably followed by both political vitriol and Lindsay's assuming. He assumes that in this instance, A cause B, while history indicates A and B tend to be complete. A respondent conducted an evidentiary and perhaps causal link could have been established, potentially justify a gag order, but the court's baseless conclusions, the assistant attorney's and the assistant attorney's empty system for 30 plus pages. Extensive. I shouldn't say about the reported gravity. That's not good. So I don't want to make it sound as if I don't think that these people could be dangerous. I'm just saying they're not stirred up, not riled up by Trump. The court's baseless conclusions, the assistant district attorney's extensive insistence for 30, say dozens of pages. About the reported gravity neither makes this situation I want to be very careful that they don't think I'm being dismissive, because that's going to make them pissed off. Court's baseless conclusions. This is an extensive insistence for dozens of pages about the gravity. That's much, much better. Much better. When I was looking at this paragraph before, something was bothering me. This is way better. Much better. Few word change just changes the whole framing of it. The court's baseless conclusions. Undeveloped conclusions. Two is better. The more deferential I can be while still attacking, the better. The court's undeveloped conclusions, and this is an extensive insistence for doesn't pay by the gravity. neither makes this situation unique nor comes a heavy presumption against the order's constitutional validity. Perhaps recognizing the tenuous legal footing of respondents' orders, the district attorney has tried to take shelter behind legal finding of other courts where Trump has been gagged. The order's legal vacuity find no reprieve through any prior rulings. The decisions issued by Judge Shotkin and District Court Circuit Court found that bear no relevance to assess the validity of gag that needs to meet a higher standard of New York State law. The gag order issued by Judge Engelron was a civil trial, and its scope was far more limited than sweeping orders issued by the respondent. Engelron specifically limited his gag order to a little bit more deferential to him. So specifically limited its gag order to restrict Trump from attacking court staff. In the case, Trump was completely free to attack witnesses, Attorney General. I'll put this up here. I'm leading more into civil trial. So, significance distinguishes civil trial from criminal trial. Cannot be overstated. That's a little strong. Should not be underestimated. That's better. That's a little more accurate. Same as it's between a civil trial. Civil trials. Should really close this out with another sentence. Based on the foregoing, it's evident that the respondents and district attorney's efforts to portray sweeping gag. Betray response. Based on the foregoing, respondent district attorney's efforts to portray respondent's sweeping gag orders in a New York criminal trial is that's it. Get back to Judge Richard's orders. Judge Merchant's orders are groundbreaking. Respondent district There's no special Donald Trump exception in the Constitution. There is no special Donald Trump. There is no special Donald Trump exception in the United States Constitution. Oh, criminal defendant. Judge Mercer like groundbreaking. Responding to this attorney strength rather than imply this only this happened to Trump over and over again. Need to call the service. No criminal defendant in New York has been altogether silenced from issuing speech that, but for the proposed gag order, is completely legal. out of court speech. Good. That's good. No legal argument supports the respondent's misanalysis of the law. While decision would like to pretend that the justification for the respondent's gag orders are settled law, there is a surprising doubt Supreme Court precedent that is ever found sufficient justification for speech. And attempting to refute few petitioners claim that Judge Merchant had no legal right to engage in a balancing test. This cites 3 cases: Sale Times, Co. v. Reinhardt, Shepard v. Maxwell. Oh, that was one. Shepard v. Maxwell. Thank you. I can be brown, I can be green, I can be brown, I can be green. Wait, no, that's not. I can be violet sky. I can be purple, I can be purple, I can be anything you like. That's 3, 4. Not one of those cases deals with a prior restraint of free speech of a defendant. Sometimes we deal with the court's rights obligations to curtail potentially intrusive media content that have a capacity to harm a criminal defendant. That is entirely consistent. Petitioners those decisions are entirely consistent with petitioners' claim that the court exclusively. The First Amendment's conflict with defendant's right to a fair trial. Gentile doubt restricting free speech from attorney. The Gentile court explicitly stated that attorneys are more subject to free speech than people who are not officers of the court. It's just a concurrence. I agree with much of the Chief Justice's opinion. In particular, I agree that a state may regulate speech by lawyers representing clients, but more readily than they may regulate the press. Lawyers are officers of the court. Okay, fine. The overarching principle of Supreme Court cases referencing lawyers' implication resoundingly weigh against issuing against a criminal defendant. Cherry picking select passages in those cases construct a license to issue a gag order on a criminal defendant is akin to highlighting particular passages from the story Noah to construct a license to abuse animals. Love it! The respondent utterly failed to cite a single case in American history where a criminal defendant other than Trump was legally silenced from his free exercise of otherwise legal speech. Or failed sentencing where other than Trump, where the balancing test was employed between competing constitutional interests. Curiously, in attempting to refute petitioner's first argument, the assistant attorney cites the District of Columbia Circuit Court's questionable claim that the state's interest is a compelling need. This display of his counsel's failure to fully appreciate petitioner's initial argument. Get him! Get him! The balancing test advocated by Supreme Court Nebraska Press Association v. Stewart is only employed if this constitutional right that is impelled by free speech. The notion that the court's interest creates a compelling need to warrant trampling on free speech is irrelevant at that stage of the Analysis. The issue of an existing compelling need versus a non-compelling only relates to private speech limitation. In analyzing said limitation, after was issued. In other words, after limitation was assessed, we can examine whether or not a compelling need existed. Invoking reported and generously labeled non-constitutional compelling need has no place determining whether or not a balancing test can be invoked. I don't like purported, that's not right. Let's just take that. Invoking a generously labeled non-constitutional has no place. Moreover, the notion that this interest creates sufficiently compelling need to abridge free speech has been repelled by other circuits. This is my second. Moreover, the notion a state or court interest in the family. Sufficient punch, power, ammunition. The notion that a state or court interest has sufficient sufficient gravity. Sufficient weight to warrant abridging free speech has been upheld by the courts. They instruct that they must suffer through the free speech of the community, even if it disadvantages the state. That the state or court interest in fair administration of justice. The state take out court. The state interest in fair administration can muster sufficient weight to warrant abridging free speech has been upheld by the circuits. They instruct the state must suffer through the free speech of the community, even if it disadvantages the state. The perspective of the 6 and 9 circuits is entirely consistent with fundamental principles espoused in petition's application. Specifically, the court's authority to entertain a request to place a prior restraint on free speech must be limited to situations where the court is protecting a basic liberty and never to fortify the state's ability to convict the accused. Good. Good. Okay. Based upon the evidence presented, the respondent could not issue a legally viable gag order without an evidentiary hearing. There are two words glaringly missing from the district attorney's opposition to this application. Causal link. There's no discussion about it. Our opponents provide no evidence of most of the existence of a causal link can offer. Next, Minister, why is fishing altogether ignored? Legislative Trump statements and statistics about third-party actions are not a causal link. This, during the precise time that there was an increase in Trump statements, was also a significant increase in New York Times articles that reference both Trump and District Attorney Alvin Bragg. Simply, while Trump made comments on platform X over the past 14 months, there was a significant increase in attacks against Bragg on that platform. Nobody suggests that the New York Times, the social media figures, and X spurred an increase in corrosive third-party actions. Yet, without delving into the existence of a causal link, it's probably made a conclusive findings. The fact that Trump's it was specifically Trump statements which caused the negative third-party actions, and it's I'm not intimating that case law. Always obligates court to conduct an evidentiary prosecution gag. Rather, it has to provide evidence of causal link. The court must reject the application or conduct an evidentiary hearing to remedy the movement's shortcoming. Movement's fatal shortcoming. I can be brown, I can be brown, I can be blue, I can be violet sky. I can be purple, I can be purple, I can be anything you like. Insert think we're good? We're good. I'm gonna send this over to Debbie. Debbie! I'm gonna get this from you because I gotta get it out to them. They gotta print it. Jesus, I don't know what any of this crap is happening. I'm crazy. How am I gonna do all this? I don't even know if I got this before. I said that I think I got that. I remember seeing this. Third party and third party, make them the same. No, I mean it's possible I made a mistake. but not necessarily. Because I'll tell you, explain to you. You're asking a good question. I'll tell you why that may be accurate. I'd have to look through it again. If I'm just talking about generic third-party actions, it's not capitalized. If I'm talking specifically about the third-party actions that Trump purportedly inspired, that's a defined term. That's the only reason it would be capitalized, because it's a defined term. In other words, I said when Trump, those actions which are the impetus for this gag order, defining as third-party actions, capital T, capital P, capital A. And any other time I use the term as far as like referring to, third parties who are inspiring that action, people on social media and stuff like that, who are inspiring those people to act that way, it's not capitalized. Good catch, but I think you're probably mistaken. Thank you, Miss Ignomy. Thank you. This was supposed to take 2 hours and it took 5. God. I didn't get to finish it. Sometimes wish I'd never been born at all. Carry on, carry on. I didn't even create a playback. Effort! Too tired. I need to go to sleep. You made a press argument about limiting availability to the gag scope of questions. Yes, I don't know what that means. Your question was logical. It was a natural question to ask. All right. I think it's time. I think we're gonna wrap up over here. Debbie, I hope you can get that back to me soon. Where are we at, Debbie? How long is it gonna take you think? Debbie, where's Debbie? She's probably working. Let me check out over here. See if I missed anything. As the press passed Comport with Shuttlesworth v. Birmingham, person faced with unconstitutional licensing law may ignore and engage with impunity exercise. I'm not thinking about new arguments. I'm done thinking about new arguments. It's not happening now. Not happening. They like Miranda, right? Obviously try, but the quote is money. With the right secured by Constitution involved, there can be no rulemaking or legislation which would abrogate. I'm not changing. I'm not doing it. I can't even look at that. I can't. I'm not going to think about whether that's potentially beneficial or not. Might be. I don't know. I need a minute. Okay, I'm muted. Hey, look over. Tired. I need sleep. Okay. I don't care about May 5th, May 6th. Okay, I don't care. I'd rather probably be May 5th. It's probably better May 5th. Just so it doesn't look like it's hot off the presses. And in some parts of the world, it's May 5th. Second of all, Nathan, are you awake? I'm asleep, okay? That's tired. I'm thinking like I have to convert this into like crap. I have to convert this into like a PDF. And it's gonna be like a special type of PDF. Like I'm supposed to be in court at 10 o'clock, and it's over an hour away with traffic. And I have to print out copies, although I'm supposed to be giving it to what's his face to print out. Gotta be mean, everything more. I need a vacation. And I have someone in my X, my DM, who's like harassing the hell out of me that like I'm not like following up on some potential business thing, which is like something he knows I never wanted to do in the first place, and now he's making me crazy while I'm sitting here dealing with this crap. I'm like, are you kidding me? Are you kidding me? Are you kidding me? Are you kidding me? I don't know what. Yeah, someone slid into my DMs. It's a dude. Isn't that kind of sliding? I don't speak the way you kids speak about when you say sliding into my DMs. Let me see if Debbie got me finished here. Any chance? Any chance, Debbie? Any chance? Thanks got it working. She was working on it. Then I edited it. She stopped. Oh, wow. Yes. Go take a shower or something. Every citation in the new doc has to be marked before the TOA can be generated. I'm halfway. Oh, Jesus. Oh, Lord. Oh, Lord. Oh, Lord. Oh, Lord. She's halfway. It wasn't you. Shut up, bastard. She's halfway. She's halfway. Oh my God. I know she's working as fast as she can. I'll share with you all what I got going on here. First, I got this going on. It's a cartoon. Good stuff. The two things I saw which I thought were interesting. Two things I saw. Da dee da da. Da dee dee da da. I'll share this with you. Rachel Maddow is crazy. Look at this crazy boy. Look at this crazy boy. Look at this crazy boy. Oh my God. I don't hear it either.
Party. They would this year take a stand. Washington State Republican Party. They would this year take a stand against democracy. And I do not mean this as a metaphor. I am not performing political analysis. I am literally describing what they literally did.
Which, it's funny that she uses the word literally twice, because this person, Rachel Maddow, a court has said that when she says literally, it literally does not mean literally. She's the only human known to mankind who, when she uses the word literally, a court has said that it is obvious that when she uses the word literally, it does not mean literally. Okay? And she just said literally twice. God. This crazy. This crazy kid.
We do not want to be a democracy. Originally, congressmen were elected by a direct democracy, senators were elected by their state legislatures, and presidents are elected by the Electoral College. We are devolving into a democracy because now congressmen and senators are elected by the same pool, a direct democracy. And with the national popular vote coming, we're going to be electing our president by a direct democracy too. Bad idea.
Bad idea. We are devolving into a democracy. We do not want to be a democracy. Okay? They decided.
Yep. Based. Yeah. Everything that woman said, and over and over again. Over and over again. Oh my God. Yes. We want to have nothing to do with your type of thinking, Comrade Maddow. Yes. But she's talking to these idiots. Who don't realize that democracy is tyranny. Is tyranny of minority by the majority. Imagine if we had a democracy since our inception. You think there would have been a civil rights movement? Think there would have been the abrogation of slavery? No. Nope. So, yeah. This idiot here is sitting here saying, can you believe the Republican Party is now admitting they literally don't want to be a democracy? Literally. Yes, you actually got something right. Yes, you did. Good for you. Good for you, Rachel. Good for you. Oh my God. Constitutional Republic. That's what we are. All right. That's the first thing I want to share with you. Next thing I want to share with you is this guy. So I thought this was an interesting thing from him. I don't know the story with Nickelodeon. But let's see what we got. Zach, why don't you?
Florida was saying the exact same thing about kids and creepy stuff at Disney that liberals now find intolerable at Nickelodeon.
They do?
He was just
They do? They do? What's happening in Nickelodeon? Do you guys know what's been happening at Nickelodeon? Do you guys know what's happening on Nickelodeon? Do you even know what's happening on Nickelodeon? Now I'm curious. I want to see Nickelodeon protests. How do you spell it? Is it this way? Yeah. Let's see what they're in the news. Let's find news stories. Nickelodeon story star Victoria Justice says she found on the filming first ever sex scene. Fairly Odd Parents. What's quiet on set? Who's Dan Schneider? Yeah, I'm curious. I don't know anything about this Nickelodeon story. I've been too busy. I'm literally learning this as we on the air with you. One of the subjects documented delving behind the scenes of children's television. Nickelodeon is taking legal action against the show's producers. According to a complaint filed in LA County, Schneider is suing the producers of the show Quiet on Set, the dark side of kids' TV, for making false statements and implications about him. Schneider claims that the show repeated. Is this the guy from The Sun, Dan Schneider? Is that him? Repeatedly made it seem like he was one who committed crimes of child sexual abuse instead of people who were convicted of those crimes. Schneider says in his statement, "I have no objection to anyone highlighting my failures as a boss. It's wrong to mislead millions of people to the false conclusion I was in any way involved in heinous acts like those committed by child predators." The first two episodes delve into the history of Dan Schneider's rise to the top while working at Nickelodeon. It's said by numerous people in the documentary that Schneider was Nickelodeon's biggest moneymaker when it came to creating comedy shows for kids in the late 90s and 2000s. Both writers and actors had documented that Schneider was unapproachable and created a work environment that was friendly on the surface but tense underneath. Interviewees recalled Schneider making jokes for people to do things that never really felt like jokes but instead felt like commands. Schneider's ultimate demise came in the wake of the Me Too movement, which gained national attention in 2017. He was in the middle of two shows, Henry Danger and Game Shakers, and the movement led to growing awareness about sexual harassment and abuse in the workplace. An anonymous customer remarked that once the Me Too movement started, she felt comfortable going to her union about the stuff that was inappropriate. She was told that she was not the first complaint. After that, Nickelodeon launched a second internal investigation into Schneider, which ultimately ended with the network paying him $7 million to end their contract. According to Kate Taylor, a reporter of Business Insider, there were no instances of child sexual abuse found, but the investigation did find evidence of being abusive to others in the workplace. His show Game Shakers ended in 2019, followed by Henry Danger in 2020 after Schneider left Nickelodeon in 2018. Schneider responded documented a few days later when he published a video discussing the allegations with former iCarly cast member Bobby Newman. He apologized for the behavior he had towards some of his colleagues while working the show. Schneider said if people were uncomfortable with jokes made in his shows back in the day, that the best course of action in his eyes was to edit the jokes out so people could still enjoy them. I don't know what that means. If you edit them out how anyone's enjoying them, that's a little confusing. Schneider is suing because defendants falsely state or imply that Schneider sexually abused children who worked on his television shows. Never did or was convicted several times during the document. It stated that Schneider never did or was convicted of sexually abusing any child and that the implication he did so is defamatory. The complaint alleges that the show Quiet on Set was put on the sake of clickbait ratings and views. So, yeah, that's what he's talking about here.
Dismissed as a hick and a bigot, but why would a kids' content factory like Disney be all that different than the one at Nickelodeon? A 2014 CNN report discovered that at least 35 Disney employees had been arrested for sex crimes against children, and in 2021, Disney child star Allison Stoner confessed she only narrowly survived the toddler to train wreck pipeline. The next year, child star Cole Sprouse told the New York Times that young actresses at the Disney Channel were heavily sexualized from an early age. DeSantis wasn't wrong, but we're so tribal now, the left will overlook child fucking if the guy from the wrong party calls it out. When the evil governor of
Isn't it weird that he's become like the voice of sense? Isn't that weird? Isn't it weird? It's so weird. So montage of all sus things Schneider had the kids doing on multiple episodes. Should I try to find something here? Yeah, I don't even know who Dan Schneider is. I think this is why I end up never going to places like Gigs and Gamers. Yeah, I should check my. Let me check where I'm at on that. Give, send, go, and Trump. Nice. 18-2. 18-2. Joe, where's the spot to find the link for tomorrow's Court TV? I should try to find it. Launch first part. Arguments. I'm trying to find out how to watch it for you. Live stream. There you go. Wow, that is such a beautiful room. Oh my God. Oh my God. This is the most beautiful courtroom they say in New York. Look at this thing. I'm going to show you. I'll share the link. I'll share the link with you. Look at this thing. Wow. Wow. Just wow. That is amazing. Wow. I'll share the link with you. Thank you very much, Haley. Yeah, I was told that's the courtroom. I'm gonna be I may be arguing tomorrow if they let me argue. Wow. It looks like a cathedral. Yeah. Yeah. You think? Here's the link. Wow. Wow. I can't stop saying wow. 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 I'm sure in person it's even way more impressive. It'll be 10 a.m. Eastern. I've got to get these damn papers in. Ugh. Please, Debbie, please, Debbie, please, Debbie, please, Debbie, please, Debbie, please, Debbie. It's my moment. They say this is nicer than the Court of Appeals. Yeah. It's crazy. Yeah, I know. I've gotta like sort of get acclimated to it. So it's like, oh yeah, this is another friggin' room. It just might be the nicest room I've ever seen in my life. This whole courtroom. That's crazy. Look at that courtroom. Oh my god. Are they going in there? Potentially. I don't know if they're gonna let me in. Wow. I'm just astonished. Yeah, I'm not gonna wear my hat in there. All right. Let me see. Let me see if I got anywhere. Let's see if that can get back. Come on, Debbie. Please. 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 Fun. She left them. All right. Usually show you from the others from this side. I'll show you the side angle. Check this out. That's the side angle. This way you can see like the murals in the back over here. This is the bench where the justices sit, and the murals in the back. Wow. And now I'm nervous. Now I'm nervous. It's not for me. This is for. Let's go. It's really incredible. It's an incredible courtroom. All right. This is what I'm going to do. I'm going to log off now because I'm tired. I don't know what's going to happen with that. I don't know what's going to be. I don't know what's going to be. But I'll tell you this. My arguments are far stronger than my adversaries. It's not even close. It's far stronger. They don't have a constitutional leg to stand on. So let's go get this. Let's go get this. Fix America. Let's go. Let's go. Let's go. Oh, God bless you. God bless you. God bless you. Did you know how to fix it into PDF? Bookmarked? Do you know how to do that? Because that would be amazing. Do you know how to do that too? If not, I'm gonna have someone like walk me through it. Okay, there's 4,000 you watching here. Somebody has to know how to do PDF. One of you has to know how to make this PDF bookmarkable. 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 Somebody here has to be like an expert in PDF. Somebody. Yeah? Really? Seriously? I don't know if Nathan's awake. Bookmark to table contents, table authorities, legal arguments. You know, basically everything in the table. Yeah, to match the table contents. Wait, what's he saying? Open your PDF. The page which to bookmark and acrobat. Click View, Tools, Content Editing. In the Tools pane, click Add Bookmark or click the Options menu. Okay, we're going to try this right now. Okay, first I got to download this. Maybe I can do this in like 3 minutes or less myself. That'd be amazing if I could do that. Okay, download. Edited. Okay. Let's see what we got here. Beautiful. Beautiful, 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 beautiful. Oh, so beautiful. All right, beautiful, beautiful. Okay, here we go. Here we go. Table contents. Okay. Now, let me open up my PDF. Let's see if I can do this without sending this over to Dropout Recruiter. Maybe I'll get a little faster this way. It sounds like it should not be that difficult to think, right? It shouldn't be that difficult. Okay, so menu, open, download, no, okay. Create, where's my create? Yeah. Yeah, like that. Okay. Okay, leave me alone. was really fast. It was like a half hour. It took her. I got it done. Don't worry. Oh no, I lost my thing. Oh, damn it. Damn it. Wait. Here it is. Okay. Don't worry. I think I got this. Create. Because it's open. Is that the problem? Retry. Yeah, you say open PDF on the page you wish to bookmark. And fine. Now click view tools. This is not happening. I don't have that. Tool. Edit. View tools, content editing. Tools. View. Oh, here it is. No. View, rotate view. Okay, so maybe a page you wish to bookmark in Acrobat. Click view and tools, then content editing. All tools. It's content. Yeah, what is a PDF? So, content. Oh, it looks like it has bookmarks. It looks like it put bookmarks in here. They did put bookmarks in here. Son of a gun, look at this. 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 Bookmarks. 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 Oh, yeah. Conclusion. Oh, yeah. Table of thought. Oh, this is so good. Oh, this is so good. This is so yummy. Oh, my God. Yes, 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 yes. I guess it's done automatically. They did it automatically. All right, fine. Now I can just upload this thing. Upload it. Okay, so uploading this thing. So first up, let me email this over. Where's the save? Save this. Save as. Save as PDF to my computer. Downloads from desktop. Put it in my work. And create a folder. Because I need a folder on this one. I'll call it Trump. Save. I'm going to email this over to Ron. I see you said there's a PDF that I think I got it. That'll check that out. Thank you. Let me send this over to Ron. Okay, so I sent that to Ron, and now e-file. Let's go to e-file. E-filing. Get this done. Get this done. Get to bed. Reply memo, reply to motion, reply brief. Close enough. Memo law, reply brief. Reply brief. Nope, that's not it. Reply brief. That's close enough. That's not right. I gotta get my desktop. Go to work. Trump. I don't know. Law. Open. Next. Submit digital copies. Beautiful. Okay. Just gonna email this over to Tisney. Plus email. Okay. This thing went through. My reply brief went through there. Now I go here. I'm going to set compose to things and to this. Attach files to my computer. Edit a memo law. Boom. And send. I think I'm done. Was it good for you? It's done. It's all done. We're witnessing what may be well be a part of history. Possible. This would really be a part of history if I lose. I have to lose tomorrow, and then I have to lose in New York, in the Court of Appeals, and then win in the Supreme Court. And then you're watching a losing step toward making history. Because honestly, if I win tomorrow, am I really going to win tomorrow? I will say this. If I orally argue tomorrow, I'm going to push very, very hard on one thing, one specific thing, for the court to recognize. If you somehow think that there's something about this order that has constitutional validity, the one thing that cannot possibly stand is this notion that Donald Trump talking about Michael Cohen may possibly intimidate him from testifying. And to the extent that the order restricts him from talking about Michael Cohen, that must be struck now, today. That's really, and I'm going to be frank with you, because I don't think they're going to grant my relief. I don't think they're going to grant it. That's the one thing, I think that's the one give they might give it. That is the one give that they might give me. And if they give me that, everyone will know about this case. And that's the one they really should get. And that will help create enough support. I can keep going further. That's the one thing I'm going to be like, give me this, recognize this. That cannot possibly be a reasonable finding of fact. That there's any sort of concern that Michael Cohen, his former attorney, convicted perjurer, may somehow be, who's gone on the air dozens of times, trashing him about everything from his integrity to him being competent to his body odor. There's any chance that something Donald Trump may say would keep Michael Cohen from testifying? Because it doesn't make any sense. So it's called big upping. You got this, man. I think so. Thanks for your help. I ended up getting it sorted. You inspired me. Anyway, I thank you all for joining me. Tomorrow, 10 a.m. I'll drop a link in case you missed it. I'll drop a link where you can find it over in Locals. All right? You can basically get in there. Okay? I don't know if I'm going to be making it into the room. The clerk says I'm not orally arguing. Ron and I don't understand how that's possible. That is what the clerk said. So I don't know. When you win, you must admit we're. We'll see. Good night, my friends. Godspeed.